Which you represent.
Which I represent. It's a clear decision. It's a clear repudiation of the legal foundation beginning in 2002 that the FCC put together of relying on what they call ancillary authority to govern and police the activities of Internet access providers for doing the wrong kind of things. In 2002, the FCC said that cable modem services, and then later they said that telecommunications services that provided Internet access were not telecommunications services, they were information services. Many thought that was the wrong decision at the time, and a lot of the assumptions, the policy assumptions that led to that decision haven't panned out to be the case. So, for instance, in 2002, they thought, many policymakers, that by 2010, consumers have many more choices for Internet access. There would be much more intermodal competition. You would have broadband over power lines and satellite and wireless. And what we've come to learn is that for the foreseeable future, most consumers will have one or maybe two choices for high-speed Internet access. And so these companies are really the gatekeepers and control the on-ramps to the Internet, which is a public forum. So because of their gatekeeper role and because of the service they provide, they really ought to be considered essential communications platforms, just like the telephone. And if you consider them to be essential communications platforms, which I think the Internet has replaced telephony as an essential communications platform, then they ought to be treated as telecommunications providers. Once the FCC does that, which would be to reverse the 2002 decision, then they're on solid legal foundation, and then they can proceed forward against the very acts that Comcast engaged in, which caused this complaint to happen in the first place.
And is that the Title II reclassification you're talking about?
That's the Title II reclassification issue. It's not that complicated a procedure. Essentially, the procedure happened in 2002 to declassify, and the Commission can revisit that decision and reclassify into these services into Title II. It does not mean, however, that they're subject to the full bore of Title II regulations. We wouldn't be talking about re-regulating these providers. We'd be talking about creating a solid legal foundation so that the sort of light touch proposed rules that people are talking about to protect consumers from some of the most egregious behavior are in place. And that, I think, benefits all stakeholders because you have certainty at that point for innovators in Silicon Valley that they can come up with products that won't be blocked or interfered with. The telecom companies and cable companies have certainty because they know what the legal foundation is and what the rules are. And consumers have certainty that their Internet experiences aren't going to be messed with. So I think that benefits all stakeholders in this space.
A simple decision to make at the Commission's end, but what about the legal challenges if that would ensue? Do you think they would ensue? And then what do you think of the difficulty as far as a legal fight this would produce if that reclassification took place?
The Commission never does anything that doesn't result in a legal challenge. So it keeps lawyers busy. Absolutely, there'll be a lawsuit. But the reason this case was so helpful, it was a test case. The test that the FCC was proposing to build its legal foundation failed. So if they move this forward under the Title II regime, they'll be challenged. But as long as in Title II they make a decision that's based on the facts and based on well-reasoned technical analyses, it's going to be very hard for a appellate court to overturn that. Those are where agencies are in their strongest position when a commission's making an expert determination. It's very hard for a circuit court to second-guess those kind of decisions. So I think they have a much better chance, actually, in that situation of surviving a legal challenge. And once that happens, then I think we're moving forward with some certainty on how policymakers can treat the Internet access providers.
Even during this process, you had companies such as AT&T, Comcast saying they were still committed to the idea of an open Internet, even though this legal proceeding was going on.
Yes.
Why not at least leave it at that with the idea that perhaps self-policing might be a way to go?
It doesn't work. So our view is trust but verify. There has to be some enforcement mechanism at the end of the day to keep these companies honest because while those entities since 2002 have been saying that they're for openness, We've seen examples like the Comcast situation where actually they've engaged in activity that's been the very opposite of the things that they publicly stated that they were for. And so they've blocked lawful content. And when they block lawful content, unless there's some sort of complaint process and recourse, it's very hard just to shame the companies into changing their behavior. There has to be some sort of heavier stick than that.
Some said during this process that this is a great victory for content companies like Google because, they use a lot of bandwidth, they bring it down, and virtually they see no, they see no recourse for their actions, so to speak. What argument would you make as far as you representing these type of companies about the type of bandwidth that goes off, which was initially the content moving over the lines was what brought this to the forefront in the first place?
Right. So that's where I think everyone benefits by some clear rules. The only way we get clear rules is by having a solid legal foundation, which is why I think the FCC has to move to reclassify. Once that happens, the network operators will be able to promote rules, and we'll support them on this, that allows them to engage in network management activities to deal with issues about increasing bandwidth and how you deal with the traffic that may be overwhelming a network. So those are issues that the ISPs ought to have a great deal of flexibility to engage in. But right now, they're not really sure what the rules are in that space. So I think having some clear set of rules helps everybody in that space know what to expect and where the lines will be drawn in terms of permissible activity and things that cross the line into impermissible activity. In the Comcast situation, Comcast at least initially argued that they were blocking lawful content because of bandwidth issues. But then the facts that the FCC developed in their investigation showed it was the opposite. Comcast was blocking the application even when there was no congestion on the network. So there has to be some sort of oversight that can verify what the network operators are saying to ensure that that the activities they're engaging in, especially when they're blocking lawful content, is actually done in a way that is sound public policy, promotes sound public policy.
Mark Amerikson with the Open Internet Coalition. He's their executive director, openinternetcoalition.org. That's the website. Thank you.
Thank you.
Thanks for joining us for the Communicators this week. If you would like to read the 3-judge panel's decision on net neutrality, net management, you can go to cspan.org/communicators, where you can watch all of our previous programs as well. Thanks for being with us.
Friday.